So we have an important update in the Vanderstock frames and receivers case. The ATF has now filed for Supreme Court review, and they're asking for the Supreme Court to uphold their 80% restrictions. So let's talk about what is happening. But real quick before we jump into this video, if you think the ATF needs to be abolished, go ahead and hit that like button and make sure you subscribe. Also, I want to ask you all for a huge favor. You may notice that I'm wearing a shirt here, and it's dedicated to one of the kind of OG gun tubers, Paul Harrell. Many of you may not know, but Paul Harrell is currently battling terminal cancer. And the company that does his merch and a lot of our merch, TriStar Trading Co., one of my good buddies over there, Johnny B., they are doing a fundraiser for Paul Harrell. You can purchase one of these shirts using the details section, the link down there, and then also the pinned comment. All proceeds go directly to Paul and his family. I believe they're actually going to donate it to a cancer research foundation, I believe. So if you want to support Paul, if you want to show him some love, check those links out. You can click them down below in the details section, pinned comment. Again, pick yourself up a shirt and it will go directly to supporting them. As I mentioned in the intro, in this video, we're going to be discussing an important development in the ATF frames receivers case, Vanderstock v. Garland. This is a case we've talked about for a while, and the ATF has now filed for Supreme Court review of their frames and receivers case. This is going to be a significant case and battle now up for Supreme Court review. This is something that I predicted would happen back in January. I did a video on this, and now the ATF has validated my predictions, and they have filed for Supreme Court review. This is happening because the Fifth Circuit recently handed down its decision on a summary judgment and final judgment on this case and kind of forced the ATF's hand. Based on the procedural posture of this case and some of the lower court decisions, I think the Supreme Court will be forced to take review of this case, similar to how they recently did with the Cargill case, and I predict that this is going to actually lead to a positive outcome in some way. The ATF is hoping that the recent 5-4 emergency stays that were granted by the Supreme Court that were issued in their favor will ultimately lead to a favorable decision by the Supreme Court on the merits of this case. But in my opinion, that is a mistake that the ATF is making, and it's not going to go their way. Now, to understand what is at stake in this case and why the Supreme Court's hands have been forced to take this case, we'll have to talk about what happened prior in this lawsuit and what ended up happening to where this is now up for Supreme Court review. Originally in this case, the original plaintiffs, FBC and Tactical Machining, sought preliminary injunctions to halt the enforcement of the ATF's new rule against unfinished frames and receivers. And they wanted a preliminary injunction while this case was making its way through the process. And on review, a lower court judge, Judge Reed O'Connor, granted a limited preliminary injunction against the ATF, which ultimately just prevented the ATF from enforcing that rule against Tactical Machining and their customers. Looking at the ATF's rule on frames and receivers, that judge found that it was facially invalid under the plain text of the statute and that Congress did not grant the ATF authority to regulate these types of items. Now, after that original limited preliminary injunction, other companies like Blackhawk Manufacturing Group, also known as 80% Arms, and then also other companies like Defense Distributed, also sought to intervene in the case, and ultimately they were also granted limited preliminary injunctions which protected their company and their customers. After the preliminary injunction stage, the plaintiffs sought to win the entire case by asking for a motion for summary judgment. And in response, Judge O'Connor granted the motion for summary judgment, and the relief that he granted was huge. He vacated the frames and receivers rule in its entirety, and that was a nationwide vacatur. That was a huge win because the judge struck down the entire rule, found it entirely invalid, and that rule was struck down entirely, and the ATF just didn't like that. Of course, the ATF didn't like that, so they sought review of that. They filed an appeal up to the Fifth Circuit and wanted for that vacatur to be overturned. When they filed their appeal, the ATF also sought a stay from the Fifth Circuit. They wanted to temporarily override that nationwide vacatur of the frames and receivers rule, but the Fifth Circuit did not rule in their favor. That then led the ATF to decide to go up to the Supreme Court on an interlocutory emergency basis for the first time in this case. They asked for the Supreme Court to issue an emergency stay which would prevent the nationwide vacatur which was issued by Judge O'Connor from fully going into effect. And in a 5-4 decision, the United States Supreme Court did agree with the ATF and granted their request for a stay. Now, in that 5-4 stay, the two justices that jumped the line were Justices Barrett and Roberts. Through that order, the Supreme Court stayed the summary judgment while the Fifth Circuit was going to review the appeal about whether or not the summary judgment was correct or not. Well, after the Supreme Court issued that 5-4 emergency stay, 80% Arms and Defense Distributed went back to Judge O'Connor and sought an emergency motion for a new preliminary injunction. they asked for Judge O'Connor to put back in place his prior preliminary injunctions that were more limited and only protected just the company and customers. Essentially, they argue that the Supreme Court's emergency stay only prevented a nationwide vacature of the rule, but the judge there, Judge O'Connor, could still keep his prior limited injunction in place. On review, Judge O'Connor agreed and granted the injunction to protect the companies and their customers. Of course, once again, the ATF did not like that, so they went back up to the Fifth Circuit, arguing that Judge O'Connor was directly defying what the Supreme Court said, and he was trying to circumvent the Supreme Court's recent 5-4 emergency order. Now, the Fifth Circuit disagreed with the ATF, and they denied the request to strike down that new limited injunction. But of course, again, the ATF has a very clear track record, so they went crying up to the Supreme Court for the second time. They filed a second emergency application to the Supreme Court, asking them to vacate that new limited injunction. And the second time the Supreme Court looked at this case, they did side with the ATF again, striking down that limited injunction. And they said that their prior rule said essentially no new relief could be granted until this case makes its way back up to the Supreme Court and the Supreme Court issues a decision. So the Supreme Court prevented any positive relief in this case while the summary judgment was being reviewed by the Fifth Circuit. Now, the Fifth Circuit recently did decide on the merits of this case, and in their decision, the three-judge panel partially upheld the lower court's decision, which struck down the ATF's rule. That decision by the Fifth Circuit three-judge panel agreed with the lower court judge that the rule was in fact invalid. However, the Fifth Circuit panel did state that they believed an outright vacature of the entire rule nationwide was something that went way too broad, it swept way too broad, and went beyond what the lower court's powers actually were. Therefore, they partially upheld the lower court's decision and issued an order remanding the case back down to Judge O'Connor for him to reissue a decision on a more limited scope of relief. Because of that Fifth Circuit decision on the summary judgment, the question was, what would the ATF do in response? They had a few options. They could take this case en banc. They could try to get Fifth Circuit en banc review, but the Fifth Circuit has not been their friends. If you just look at cases like Cargill, the Fifth Circuit has not been the friends of the ATF. They could try to litigate this case back down in the lower court, but again, all that would ultimately happen is a new form of relief would be granted against the ATF. I predicted and broke down in my last video about why I believe the ATF would just try to bypass all that and take the case back up to the Supreme Court because that was their best option. And that's exactly what they have now done. The Supreme Court's 5-4 emergency order that was issued prior essentially made a new relief and a new decision by a lower court or even the Fifth Circuit en banc panel almost irrelevant until the Supreme Court decides to rule in this case. And that forced this case on a single track back up to the Supreme Court, and that's where it's now going to be. In their petition, the ATF really makes the same kind of fear-based ghost gun arguments that they've always made in this case. They simply state that this court's review is warranted because the Fifth Circuit declared invalid key provisions of an important regulation and adopted an interpretation of the act that would effectively nullify its central provisions by allowing criminals and other prohibited persons to obtain untraceable firearms without background checks, serial numbers, or transferred records. The recent exponential increase in the availability and use of ghost guns is a grave threat to public safety. So really nothing new and nothing nuanced about the ATF's new arguments. It's kind of the same tired arguments that they've been making all along in this case about how dangerous these so-called ghost guns are. Now, in my opinion, I think this is a case the Supreme Court will in fact grant review in, essentially because they are forced by the lower court's decisions, by the procedure of this case, and also by their own emergency orders to have to review this case. The Supreme Court has already recently granted review in the Cargill case, that bump stock case, which dealt with similar ATF actions. The Supreme Court is currently set to hear oral arguments in that case on the 28th of February, so coming up very soon. So the Vanderstock case is headed to the Supreme Court for review, and at the very least, this case will be put on hold and then ultimately probably GVR'd after the Cargill decision. That's kind of the worst case scenario in my opinion, but I think ultimately, the Supreme Court will in fact grant review in this case and probably strike down this ATF rule, even if they do so on limited basis, saying that it was a violation of the APA and that it went beyond the ATF's statutory powers. So major developments in this case, I think we have another big ATF case that is now going to be reviewed by the Supreme Court. But of course, if anything else develops, if anything changes, I will let you guys know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.